Ir majorta hirna dan all nefa corfuin and shinna sturin on yevra agus nyachta gras of run or when the horchun creaca. Underscore which the sofa on nilivriher agus ar nilagni fasta agus got 3 creek no for read 3 Christa Girna. Direct we beseech dear Lord our actions by thy holy inspirations and carry them on by thy gracious assistance, that every word and work of ours may always begin from thee and by thee be happily ended through Christ our Lord. Amen. I'll give question to the Minister for Children and Youth Affairs. Priority question number 60 in the name of Deputy Robert Troy, and I call on the Minister.
Thank you. Thank you, Cathaoirleach. I wish to inform deputies that the High Court is presently hearing an application for leave to petition the Court under the provisions of the Referendum Act 1994 to question the validity of the provisional referendum certificate issued by the referendum returning officer in relation to the children's referendums poll held on the 10th of November. That petition stands adjourned until January 2013. This application relates specifically to the provision of public information by the Government and the decision of the Supreme Court regarding this information. In light of these matters, it is prudent not to make comment that would be prejudicial to these proceedings. As a respondent in these proceedings, I am particularly constrained as regards further comment, and at this stage, while proceedings are ongoing, it is necessary and indeed prudent for me to restrict my comments. I participated fully in a Shannon Éireann debate on the Supreme Court decision on the 8th of November, the day of the Supreme Court decision. I made a detailed statement as part of that debate. I want to make the point that no other proceedings were underway at that point, and I would refer deputies to that detailed statement. My statement of the 8th of November acknowledged the errors that had taken place. I reiterate my acknowledgement and regret that these errors took place. In the Shannon, I did explain that the Government's information provision was well-intentioned. It was considered that in preparing information materials, appropriate regard had been paid to the McKenna principles. The full Supreme Court judgments which were now available do in fact find that the Government at all times acted in a bona fide manner. All the publications were issued with a view to informing the electorate about the referendum. The judgment in McKenna stated that the Government has a duty to give information to the electorate, as well as to clarify issues which may arise in the course of the campaign, and must do so without advocating a particular position. Governments have in fact carried out this role in other referendums since the McKenna judgment, including the Lisbon and Stability Treaty referendums. The Court has unanimously acknowledged that the principle enunciated in the McKenna judgment stands as firm as ever. The Government welcomes the fact that the Supreme Court has, for the first time since the judgment in 1995, set down guidelines on the application of this important principle. The modes through which information is conveyed are very different to those which were operating in 1995.
I have to interrupt the Minister there. The rest of the plan
Thank you.
in the official debate. Deputy Troy.
Thank you, Laskin Corda. Has this question been taken on its own, or is it taken? It is, okay. Thank you, Laskin Corda. But firstly, just to say that I think it's deplorable that it has taken 6 weeks for the Minister to come into this House and give a response in relation to the ruling. You mentioned you went into the Shannon, a house that your party wishes to abolish. And now, after 6 weeks, we have an opportunity to ask and get some limited feedback from you, Minister. This is a very serious issue. The Court granted a declaration that the respondents, i.e. the Government, had acted wrongfully in expending or arranging to expend public monies on the website, booklet and advertisements for the purposes of promoting a particular result in the referendum in the 31st Amendment of the Constitution. And despite what you say, Minister, it goes on in Chief Justice Durham in her conclusion says, on applying the correct test to the material published by the Minister, I conclude that there was a clear disregard by the respondents of the McKenna principles. The materials published by the Minister was not fair, was not equal, was not impartial or neutral, and consequently I would allow the appeal on the second issue also. Minister,
question, please.
This is a damning indictment by the most senior judicial figure in our land on your role in relation to this referendum. And can I ask 4 relevant questions and direct questions, and perhaps you'll answer them directly back to me. Who took the decision to publish this booklet? Who took the decision to hive off 1.1 million that should have been allocated to the Independent Referendum Commission? Who took that decision? And who signed off on the content of this booklet? Because shortly after the decision, there was an effort by certain ministers to dump on the AG, but by looking at this, that's not the case. By looking at the reply by one of the judges, that's not the case. And can I ask also, Minister, what is the cost implications to the state? Apart from the 1.1 million, what's the cost implications to the state? And ultimately, Minister, who is going to take responsibility for this? And who is going to be held accountable for this deplorable situation?
Thank you, Deputy Minister.
Yes, thank you. Can I say, Deputy, and I want to remind you that the government is defending a petition in the High Court, and recognising the separation of Parliament and judiciary, I have no wish, and I will not prejudice the upcoming hearings. And I'm sure my parliamentary colleagues here will respect and accept the position, indeed, that I'm in. In regard to your comments, let me quote to you what Justice Denham also said. In all the circumstances of this case, as have appeared before the court, I am satisfied that the respondents acted in a bona fide manner. Justice Fennelly, I have no doubt that this was done bona fide and with consciousness that the decision in the McKenna had to be respected. And Justice O'Donnell, who says, it should be said that the plaintiff made it clear that he was prepared to accept that the department had acted in good faith in preparing the campaign and did not challenge it on that ground. I would refer those findings from the Supreme Court judges to you also, Deputy.
Thank you, Deputy Minister. Thank you. Very briefly.
Very briefly, Minister. Almost. It's considering in the verdict of Mr. Justice O'Donnell, who points that some of the language used in this so-called independent literature was also the same language used in your speech to the launch of the Fine Gael advocating a yes vote. And you were quite rightly entitled as a Fine Gael parliamentarian, as I was as a Fianna Fáil parliamentarian, to advocate a yes vote. But why is it the same language? And if there was bona fides in terms of the wording used in this independent booklet, why did you use the exact same language in a Fine Gael document as you did in an independent document?
Thank you, Deputy.
I think myself, Minister, this was a political stunt on your own part. That's what my own personal opinion.
Question time. Final reply, Minister.
It certainly was not. And in fact, the highest court in the land disagrees with what you have to say and accepts the bona fides of myself and my department in relation to this. However, I do want to say and accept, of course, as the court has found, that the government, in attempting to fulfil its duty to inform the people, strayed beyond the boundary of the provision of information to the electorate. And I readily accept and acknowledge that we have to look at and implement the lessons to be learned from the successful legal challenge to the government's information campaign. And the government, I want to say to the House, has said that it is carefully studying the Supreme Court's judgment, which clarifies for the first time since 1995, how the government can make information available to the electorate during a referendum. And I have no doubt, Deputy, that at the appropriate time there will be considerable debate on these matters in the House, and I look forward to fully participating in that debate when the constraints which currently apply are no longer relevant, and those constraints do, Deputy, apply today.
Thank you, Minister. Next priority question in the name of Deputy Cuivín O'Quailán. And I call on the Minister. 6 minutes at least again per question. The Minister.
Thank you, Deputy. I wish to reiterate the need to be mindful of court proceedings with regard to the referendum result and the particular constraints which I face as a defendant of the High Court application at this stage. At the outset, I should point out that the activities of the Referendum Commission in respect of the recent referendum were funded by way of an allocation of 1.9 million from the sum of 3 million provided in my department's vote for a referendum on children's rights. The balance of 1.1 million was used by my department for the provision of information to the public in relation to the referendum. It is important to be clear on the fact that the report on the Referendum Commission on the Stability Treaty did not call for a prohibition on government providing information to the public in relation to referendums. This is evident in the Commission's recommendation to the effect that where a government department or agency produces an information guide to a referendum proposal, its design and content should ensure that it is clearly distinguished from Referendum Commission material. Any such guide should contain full contact details. This was the approach, Deputy, taken to the design and production of the information booklet issued by my department in the children's referendum. The approach adopted by the Government to the provision of information to the public in the recent referendum reflected information initiatives used previously on such occasions. As regards learning from past experience about potential confusion with the materials of the Commission, specific efforts were made to avoid this happening. The Department's main information tools were a booklet and a dedicated website. The print and limited broadcast advertising sought to draw attention to these sources of information and to call attention to the Saturday voting day. The booklet identified the Department on its cover and prominently displays the Department's contact details in the text. This was done twice in both the English language and the Irish language version. At the conclusion of each website page, the Department's name, logo, address and contact details were carried.
I have to interrupt the Minister. The rest of the reply will appear in the official report. Deputy O'Quila.
Yes, well, I don't doubt the Minister's intent, and I think that's clear from the question as I've posed it. My concern is that if we haven't already, that we certainly must learn from the lessons of the past. And I know that in August past, Mr. Justice Kevin Feeney, the former chairman of the Referendum Commission in relation to the Fiscal Treaty or Austerity Treaty referendum, depending on one's point of view, cautioned against this approach on the basis that it could cause confusion. It was his experience as chairperson of the Referendum Commission in that instance, in the Fiscal Treaty referendum, it was his experience that it perhaps had contributed to the creation of confusion. I note the point in relation to not identifying where it had emanated from and what have you, and that didn't apply in this instance under your own direction. I noted all of that. But I think that we have to be mindful in relation to the existing rulings, the McKenna judgment, and the need for the highest accedance to all of that. And I do believe that ultimately, and I asked the Minister, would she not also believe that this is best, the dissemination of independent assessment and information should be left wholly and solely to the Referendum Commission, applicable at whatever given time. And, you know, I would strongly recommend that commentary, post-commentary, you know, I noted that Deputy Pat Rabbitte had said following the McChrystal judgment, and I quote, "The government seems to be impeded from advocating its convictions in a matter like a referendum." You know, I reject that. That's totally untrue. You're not. What is a requirement is that the component parts of government, like the opposition voices, must be responsible for funding whatever they produce, either collectively or by their own individual party independent action.
Thank you.
So I would ask the Minister, would she accept there are lessons to be learnt and that the best practice for the future is to allow the Referendum Commission of the day to take wholly and solely responsibility for the dissemination of independent assessment.
Thank you, Curla. Deputy Reedy, again, I should just reiterate that whilst I would like to engage in a long debate in relation to the issues that you raise, I really am constrained at present in terms of that hearing in January. Certainly, the issues that you raised are ones that the government will certainly be considering, and we are, and I am certainly committed to working within the parameters of the judgment that was delivered in the conduct of future referendums. And we do have to, I do agree with you, we do have to very carefully consider the conclusions of the court. And the government will certainly be doing that. And again, I would want to welcome the fact that the Supreme Court, for the first time since 1995, has provided some very important guidelines on the application of the principle in McKenna. I do want to say to you in relation to the recent campaign that it is interesting to note that the comments that we got from the public or comments, complaints about distinguishing between our own in the most recent referendum between the Department's information initiatives and the Referendum Commission, that complaints about distinguishing between the two were not a feature, as you acknowledge, and I thank you for that, were not a feature of the many verbal or written queries that came to the Department. And just to say again that we did aim through our information campaign, and I think when we discussed it here in the House, I think it was on the 26th of September, when we discussed the referendum initially, I think all sides were very concerned about getting a lot of information out there, and the fact that there were issues in relation to the complexity of the material. And, you know, people here in the House identified again and again the need to engage the general public with the debate, to provide explanation and to encourage turnout to vote. And you will recall that on that day, on the 26th of September, that I said that we were committed to ensuring that people had all of the information that they needed to make an informed decision on the 10th of November, and that we would have the website. And much of the research that has been done in relation to referendum does show very significant gaps in relation to information. So I can only agree with you, and the government does agree with you, that these matters do need to be considered going forward, and will be considered going forward.
Deputy Quayle, briefly.
And Corley, I mean, I welcome the Minister's response, which I take positively, that the government are taking on board the situation now. It can't be more clear, and no pun intended, crystal clear, after the recent judgment. So I would certainly hope that, you know, we would arrive at a space where the Referendum Commission will be seen as the independent voice for the dissemination of that independent view to the wider public, and that anything else, you know, that has the imprimatur of government is seen to be in competition, in my view, with the role of the Referendum Commission. Better that the component parts of government, and I mean, it's just today, it's Fine Gael and Labour, it could be any combination of voices here, is to get it right and to know exactly what we can do in the future.
Thank you, Deputy.
Could I just ask in conclusion, I know we're all disappointed that there wasn't a greater turnout. There are a whole range of reasons for why that would have been the case, but was there any question in the Minister's mind, or in any of the assessments since, that confusion was in some way contributed to by the second information document? I just posed the question.
Thank you, Deputy. Final answer on this, Minister.
Well, I really do believe that my reply to that question, Deputy, has to be that there is a hearing in the High Court, and to give any further comment would not be the right thing to do. And I do have to recognise the importance of that case, and of not making any comments that might prejudice the outcome.
The next priority question is in the name of Deputy Seamus Healy, and I'll call on the Minister.
Thank you, Deputy Healy. The Government has approved the heads of the Child and Family Support Agency Bill, and has also agreed the priority drafting of this bill. The necessary legislative and organisational preparations are being prioritised so that the agency can be established early in 2013. From its establishment, the Child and Family Support Agency will have service responsibility for a range of services, including child welfare and protection services currently operated by the HSE, domestic, sexual and gender-based violence services. The functions of the Family Support Agency and the National Education Welfare Board will transfer into the Child and Family Support Agency upon its establishment. The Government's consideration of these matters, as you know, was informed by the recommendations of the Task Force on the Child and Family Support Agency, which I published in July of this year. The Task Force considered that the agency needs to be as broadly based as possible, and should include a range of prevention, early intervention, family support and therapeutic care interventions. It is my intention that the agency will have a role in supporting families and communities. It will have the benefit in this role of the 106 family resource centres which have been developed across the country with funding from the Family Support Agency. I want to assure you, Deputy, and I have seen first-hand the work of the family resource centres again and again throughout the country, and I do want to assure you that the new agency will build on the excellent work undertaken by the Family Support Agency over the last decade, and that a community-based approach will form an integral part of the new Child and Family Support Agency. I have said this again and again, and we're absolutely committed, because effectively the Child Protection Services cannot work properly if you do not have this base of community work and family support. And I have said to the workers in the family resource centres that the ethos and the criteria by which they do their work will be maintained in the new agency.
Thank you, Deputy Minister. I have to interrupt the Minister.
Yes.
The rest of the reply will appear in the official report. Deputy Healy.
Thank you, Leslie Corla. And I want to thank the Minister for the reply. And as the Minister said, there's 106 of these centres right throughout the country, 3 of them in my own constituency, Millennium in Glengool, Sparfield in Cashel, 3 drives in Tipperary Town. And they do tremendous work with very scarce resources. And they're providing essential frontline services in deprived communities affected by austerity, poverty and exclusion. And families challenged by poverty are particularly targeted in the centres. They obviously deal with early intervention and prevention, if at all possible, and provide an absolute range of services. And my reason for putting down the question to the Minister was, in fact, to seek the reassurance that she has given and to ask the Minister, in the context of establishment of the Child and Family Support Agency, to confirm the continuation of these centres and their central role in the new agency, to confirm, as I say, her support for the centres, for continued funding and proper and adequate funding for the centres, and also to seek an assurance that the centres will have a nominee on the board of the new agency.
Thank you, Deputy.
Thank you.
I call the Minister to reply.
The composition of the board of the Child and Family Support Agency is currently under consideration, Deputy. And while the composition of the board will reflect the component organisations which are being amalgamated into the Child and Family Support Agency, I do want to say to you, and I think this is extremely important for an agency like this going forward, that the criteria for board membership, and it will be a small board, will be on ensuring that the board members have the requisite mix of experience and competences needed to steer such a very large organisation. Over 4,000 staff are being transferred to this agency. This is huge public sector reform, and we absolutely have to ensure that those members guiding this on a small board, directly accountable to myself and directly accountable to the department, that they have that mix of experience and competencies needed to steer such a large organisation. I do expect that there will be somebody on the board representative of the work of the Family Support Agency and the Family Resource Centres. But the essential criteria for me, rather than the board being a board with a very broad mix of representative individuals representing various organisations, that hasn't worked as a board model, as we know when we saw what happened with FOSS in the past and other agencies. So it will be essentially about the mix of skills that will be needed to take forward an organisation of over 4,000 people. But I do want to repeat my absolute commitment, and that of the Director of the Child and Family Services, Gordon Jays, to supporting the work that goes on in the family resource centres and the work of counselling and supporting the voluntary groups. Huge numbers of voluntary groups are supported by the Family Support Agency, and that will continue.
I call Deputy Healy for a supplementary.
Cora, just to ask the Minister to ensure that there is a representative of the centres on the board. This is obviously a new situation. These centres provide a whole range of very vital services in local communities, and I do think if the reform that the Minister speaks about is to be successful, then every element of the services need to have representation at the highest level.
Come August, Tara.
I mean, I do take the point that you make, but I hope you also accept my point about the skills level that will be essential to lead, you know, such an organisation in terms of HR, in terms of accountancy, in terms of standards. I think that's really important because, you know, just to say to you that what we've often discussed in this House, and I think you've heard me say it before, is that, you know, what the Independent Child Death Review Group found and what has been very clear is that we haven't had standard models for risk assessment. We haven't had proper interagency work. We've had a huge deficit in information and management across the sector, and we've had very poor budgeting and cost management, and that was right throughout the years of the Celtic Tiger. And you know, that means there's a lot of work to be done now, and that is the primary task of the new agency, to ensure that we have a service that is really fit for purpose, you know, going forward, to give the kind of effective services to children and families that we want to deliver and that everybody in this House wants to see in place, given the range of reports we've had.
We now go on to the next priority question in the name of Deputy Robert Troy, number 63, and I call on the Minister.
Thank you, Deputy Troy. As part of Budget 2013, together with my colleague, the Minister for Social Protection, I was pleased to announce a new after-school childcare initiative, which will be targeted at low-income families and supporting parents availing of employment opportunities. The initiative is expected to receive full-year funding of £14 million to provide over 6,000 quality after-school places for children attending primary school, as well as supporting parents to take up employment. Lack of access to affordable quality childcare is a significant barrier. I see reported again today in the Irish Times and the OECD report in relation to Irish women. And it is a problem for many low-income